wonderful. So we're here for the outside the box panel. I don't know if that's to symbolize that the pieces are outside the box. If I'm outside the box as a commentator, we're all in the box of the Zoom. My background is trying to underscore our freedom of thinking and rebellion against boxes in general. Maybe too many boxes is the ultimate way to resist boxes. With that prelude, let me just say that this is a really wonderful group that's been assembled here, not by me, but I feel very lucky to have the chance to engage with all this great work. We are being recorded, so please remember to mute yourself when you're not speaking. And we're going to do the normal process of having each paper present for about 12 minutes. I'll keep time, and then I'll make a few diffuse comments about the papers, and then we can have a conversation about all of them. So with no further ado, I think we're going to go in order. So Jill and Kyle, would you kick it off?
Okay, can you guys hear me? Good? Okay, great. So yeah, thanks, Richard. Thanks, Andy, and all the other organizers. This is, one of my favorite events, and I'm really looking forward to it being in person again. And thanks to all of you for reading and working with what is quite obviously a genuine work in progress on our end. And so we appreciate the indulgence, and we're really looking forward to hearing Richard's thoughts and anyone's thoughts here. And if you have follow-up thoughts, we truly welcome them. So the paper's called Robotic Interpretation. And basically what we're trying to think through in this project is the somewhat startling fact, or so it seems to us, that there's a number of fairly prominent theories of legal interpretation, or of sort of the judicial role, you might say, in the enterprise of legal interpretation, that imagine the enterprise as one that sort of in principle does not rely upon human subjectivity as a necessary ingredient. And so in some sense, imagines the enterprise as one that in principle could sort of do away with the human judge, that the human judge is not in principle sort of necessary, but rather that the human judge, or the kind of the mind and brain and the kind of hardware and software, so to speak, that the human judge brings to the enterprise is a kind of contingent technology, and could be, again, in principle, sort of replaced by better technology were some available. And of course, historically, there's been nothing, even remotely close to the capability of the human mind when it comes to doing kind of complex interpretive exercises like this. But that, in the near future, perhaps even now in some contexts, we may no longer be in that situation. And so there may be a kind of actual set of questions in front of us around whether the contingent technology of the human judge really is the right mechanism to look to. And so this seems startling to us, because one might have thought at some level that our theory of judgment, or the role of judgment in the enterprise of legal interpretation, would sort of involve human judges essentially, rather than just kind of incidentally. And we're trying to kind of canvas this, get a little bit of descriptive clarity about the sense in which we think different theories of legal interpretation have this characteristic. Not all of them do, but more than we might think have them. And then also to offer some sort of diagnostic hypotheses about kind of why at this particular moment in time, broadly speaking, but sort of in the last couple of decades, and I think accelerating over time, do these theories with their robotic valence kind of look appealing? And so let me just say what I mean by the kind of robotic theories, and then I'll say a few words about our preliminary hypotheses about why we think they look appealing, and then Jill will take us through the example of the Yates case, which is the one that we're focused on in the current draft, to try to kind of bring it a lot more concretely. So basically, we think there are kind of two families of robotic interpretive theories. One family is the deductive family. So this is sort of very clearly the case with classical formalism, but I think it's true also of neo-formalist theories as well, textualism, originalism, but also actually lots of purposivist theories of interpretation too, which basically imagine that the answer to specific interpretive controversies can be resolved through the deductive application of abstract criteria. that can be kind of ascertained and codified before the fact, and then sort of implemented case over case. And this is a model that in kind of computer science terms, you might think of as the universal computing model, right? So what it imagines is the legislature or the framers or whoever it was that originally crafted the text has basically written a program. It's, that can be described as a kind of mapping of input-output functionality. Maybe it's a good program, maybe it's not, right? Obviously, some programs are crude, lots of text, legal texts are going to be open textured, so on and so forth. But in any case, it's a program that the judge is effectively sort of charged with running. So the judge runs the program the way that a computer would run the program. And then because we know that the programs are pretty crude, the judge might exercise some prerogatives like dealing with Scrivener's errors and other things that allow the judge to sort of patch the program, as it were, in real time. But effectively, the role is one of kind of implementing the program. So that's what we're referring to in the paper as the top-down model, the deductive model of kind of robotic interpretation. On the flip side, we have an inductive model that is kind of now burgeoning and getting a fair amount of mainstream attention with things like corpus linguistics. And this is not so much analogous to like universal computing, it's more analogous to machine learning. And so here the idea is not so much that you take abstract criteria and you apply them deductively to a particular case in order to resolve it. It's that you canvas the extensional field of past usage of a given term or concept. And from that extensional field, you can reverse engineer some understanding. You can inductively reason from there to understand the sort of meaning in some a kind of generally applicable way of the term or the concept that can then help you resolve new cases. And so here it's not so much that the court is tasked or imagined as doing the equivalent of running a program, it's doing the equivalent of going out and churning through an extremely large volume of cases. Again, historically, human capacity to do this has been very limited, though we see patterns of this way of reasoning and lots of judicial opinions, but machine learning and other kinds of tools are maybe going to enable a kind of greater bells and whistles, version of this. And so both of these, we think, for all their differences, well, for one thing, sociologically, they're kind of coming together in the sense that a lot of the people who are committed textualists, originalists, and other neo-formalists are very interested in things like corpus linguistics, and we think that's not accidental. In fact, on the contrary. But also, that there's some deeper sense in which these two approaches, the deductive and the inductive approaches to robotic interpretation, are kind of equally designed to eliminate the layer of human subjectivity or kind of rich contextual judgment on the part of the judge from the enterprise at all. And so that's at least the kind of account that we're going to give, and Jill will say more in just a minute here about how we see that playing out in a case like Yates. I just want to flag for everyone, we have some verbiage in the paper along these lines, but essentially at a diagnostic level, the direction we're thinking of taking this is that we can see sort of two reasons why these robotic interpretive theories might be appealing in virtue of their roboticism, right? Like, not that they're appealing for other reasons and they happen to, the snarky academics can come in and call them robotic, but that it actually is the robotic core of them that is appealing. One hypothesis is that it's a response to just institutional crisis and collapse, and a notion that we really can't trust against the backdrop of radical polarization and pluralism any room for the discretion or the kind of latitude that human subjectivity invites into the process. So that's a kind of familiar account. In some ways, it's usually shown up in partisan terms, but I think it's actually fairly transpartisan in some sense. And then the other idea that we're exploring, and I'm kind of, I'm not really even a lawyer at some level. I'm more of a humble country theologian. And so I'm more interested in the ways in which this actually looks eschatological, or like a kind of teleology that the common law has long sort of imagined for itself. And I think it's picking up on a trope that goes deep in the Western religious imaginary of sort of a world in which law has worked itself pure, or we're sort of beyond the imperfections of law and at some level beyond law as we know it itself. And we're finally in the kind of post-historical or post-legal regime where everything just works and there's no kind of messiness to it, and we are kind of delivered from the bondage of law. So I'll pass it off to Jill there, but that's kind of generally what we're thinking.
Okay, thanks, Kyle. And it's this is a crowd that I've not met most of you before, and so it's a real nice opportunity to to have your reactions to this, again, very embryonic project. So I'm going to take it in a more concrete direction that Kyle and I have worked together because we have similar hunches about judging and the lack of deployment of judgment in cases, especially dealing with working from text. And he comes at that through the lens of jurisprudence, and I come at it from linguistics, and particularly semantics and pragmatics. So we saw the Yates case as a kind of example of this. And you probably know the Yates case, it's the fish case, right? So commercial fishermen, just if you're not familiar with it, commercial fisherman catches illegally undersized fish, gets busted by federal authorities, but on the way back to shore, throws the undersized fish overboard. Now, the Sarbanes-Oxley Act prohibits destroying or concealing a record, document, or tangible object with the intention of impeding or obstructing a federal investigation. And so, of course, that's a provision that's designed to close a loophole that Arthur Anderson managed to slither through in the wake of the Enron document shredding accounting scandal. So the question, as it was framed by everybody, right, all of these opinions, is a fish a tangible object? And Yates comes out 5-4 for the fisherman, so he gets off. But it's a funny ideological cross alliance of opinions here. There's a plurality by Ginsburg, an Alito concurrence, and a Kagan dissent. And all of these opinions, though, focus on what is the meaning of a tangible object, which is, we think, a topic that is, why do we focus on that? We think it's the kind of question that both robotic approaches can digest. Now, we'll focus on the Kagan dissent first. So it's the simplest one. She shows this top-down deductive approach, just simply working from dictionary definitions and their criteria. It's practically as simple as a fish is an object, look it up. It's tangible, you can touch it, look that up. What part of tangible object don't you understand? And that's not the end of the opinion, but that's basically the method. And there's something persuasive about that, right? If you take the text seriously. The Alito concurrence is the one that really displays this most sort of bottom-up inductive approach. So his method is to think of examples of tangible objects, actual usages of tangible objects in the world, or actually an elicitation where, give an example of a tangible object, and a fish doesn't spring to mind, he says. Or think of things that are in the construction, like with records and documents and tangible objects. And is a fish like one of those things? Clearly not. Now, the plurality opinion by Ginsburg is a little more eclectic, applies some interpretive canons, the ones you would expect, Noscitur Associates, to say that tangible objects, interestingly, the ordinary meaning of it might include fish, but the context pushes us toward a narrower reading of that ordinary meaning that is limited to objects that one can use to store information. But they get there also by canvassing a lot of examples. So examples, again, this inductive input of object and other statutes, really looking earnestly to see whether fish belongs in the club here. And our point is that both sides treated this as a semantic question, a question of the scope of tangible objects. What are the criteria top down from getting into that corral? And does a fish meet those criteria to get in? Versus, let's look at the corral itself and what stuff is in it. What are the things that we call tangible objects? And let's ask if a fish fits in this club.
Jill, I'm sorry to interrupt you. We're a bit over time now. Could you wrap it up at this point?
Yeah, sure. Okay, I'll just say, we think that we can show that, what we've tried to show in these hypotheticals is that you could imagine storing, if you could store you could imagine a technology that stores records in the scales of fish. And if so you could have a Fisher-Fisherson case that is exactly like Enron, where of course they get convicted under Sarbanes-Oxley. By the same token, you can have a Yates type case, our William Butler case in our hypothetical, where somebody dumps a load of flash drives into the Gulf of Mexico. And of course, that should not be an acquittal, just like the Gates case. So it doesn't have anything to do with whether a fish is a tangible object or not, or even the meaning of tangible object. When you step back away from it, you can kind of see that that tangible object is so vacuous as to be sort of like a dummy, a semantic dummy in this sentence. And we think that it takes pragmatic judgment, or the kind of judgment that, you know, when I see a sign that says ID must be carried, I know I have to have ID on me. But when I see a sign that says dogs must be carried, that doesn't mean that I have to be carrying a dog. So those are the kind of inferences that we think that that humans are really, really good at drawing, so much that we don't even notice that we're doing it. And that we feel is out, you know, that's what we think of as being, you know, in a nutshell, human judgment. All right, interested in your questions.
Okay, great. Chaz, you want to take it away from here?
Yeah, thanks so much, everybody. And thanks again to the organizers. Are you guys seeing the screen that just has the slides and not my notes? Okay, good. So the topic for this talk is the thesis that federalism is beneficial, in part because it promotes innovation by turning the states into laboratories of democracy. And you see this claim in many, many papers in political science and economics and in law scholarship and in case law. And the main thesis is that this is a myth. Simply put, we don't think there are 50 state laboratories of democracy. We think there are hundreds or perhaps even thousands of laboratories of democracy. And they are not state officials sort of toiling away at their desks trying to formulate new ideas for new policies. For the most part, ideas for new policies come from national interest groups engaged in national fights in any jurisdiction where they have political leverage. So in the talk, I'm going to just try to do two things. I'm going to first explain what we take the laboratories idea to be, and then explain why we think it's a myth. And then I'll talk a little bit about some doctrinal consequences, although I won't have time to get into everything that the paper gets into today. So first, the idea, the laboratories idea. The judges and scholars who invoke this idea that federalism turns the states into laboratories of democracy tend to do so almost, they use it almost like a slogan, and don't ever explain precisely how the idea is supposed to work. But we think it has to be one of two things. So it's either the idea that our federalism puts the states into competition with one another, which produces ideas for the same reasons that technology companies produce new ideas or pharmaceutical companies produce new ideas, because they're trying to attract things that they want as a result of producing those ideas. So in the case of companies, it might be revenue and you know, stock value. In the case of the states, it might be votes and dollars, right? So it's either a theory based on competition, or maybe the claim is something like the process of natural selection. So the idea is that federalism divides power among jurisdictions that are geographically separate, and that those jurisdictions are going to have their own local conditions, and so they're going to respond to those local conditions. And out of that process, sometimes we get good ideas, and those ideas can then be copied by jurisdictions that want to also use them. But either way, you can see that central to the idea, the laboratories idea, is this notion that it is states and their officials that are the primary sources of good ideas for new policies. Now, Susan Roque-Zackerman gave us some reasons to be skeptical of that claim about 40 years ago now. She gave us reasons to be skeptical, both that state lawmakers have the right resources and that they have the right incentives to come up with ideas for new policies. So just as a factual matter, state lawmakers tend to be highly underpaid and to be understaffed. So there's a problem in thinking that they have enough resources to be you know, devoting any of their time besides governing to sort of thinking of new ways to regulate their citizens. And then also as a structural matter, state lawmakers are going to encounter a fairly powerful temptation to free ride. Since experimentation is inherently risky, Entrenched incumbents will tend not to want to rock the boat, thinking that their seat is safe and why risk it. So any theory of state policy innovation is going to have to provide an answer to Rose Ackerman's challenge. And we think that the laboratories idea, as it tends to be invoked, doesn't supply that answer. Now, we think the laboratories idea, as it tends to be invoked, goes wrong by focusing on the wrong actors. It focuses, as I mentioned, on states and their lawmakers, so institutions or people and institutions that are internal to state governments. When instead, what we should be focused on are the hundreds or possibly even thousands of interest groups, advocacy coalitions, donor consortia, and the like, with which those lawmakers regularly interact. These groups, in our view, are the true engines of innovation in the states. And they are highly active in state and local politics. And indeed, they form networks that many political scientists think are constitute the two major political parties today. So these groups invest lots and lots of resources formulating new ideas for policies. And then they take those ideas and neatly package them for lawmakers in the form of MIC legislation and MIC research and MIC talking points. And their goal isn't typically to give any one state an advantage over others or to help any one state adapt to its local conditions. Their goal is to change the national landscape by diffusing their preferred policies across as many jurisdictions as possible, as quickly as possible. Now, of course, you still need lawmakers to instantiate those ideas. But we think it's misleading nonetheless to think about state officials as running their own laboratories. They are actually just nodes within two much larger political networks constituted by hundreds or thousands of interest groups. And they typically are not the nodes within those networks where the policy ideas first originate. So the Brandeisian myth is the idea that we have 50 laboratories operating within 50 state governments, when in reality, we think there are hundreds of laboratories that operate outside of state governments, but use the state governments to achieve the results that they prefer. And this insight supplies several answers to Professor Rose Ackerman. So the first is these political networks of interest groups provide material support for the enactment of new policies. And they do this in two ways. They provide shortcuts and cues to local and state officials who don't necessarily know what they think about a myriad of things that are in front of them. And so they can help them to figure out what their view on any given policy should be. And then they do much of the legwork that state officials who are persuaded by these ideas will need in order to transform those ideas into actual law. And then from a just purely electoral standpoint, these organizations and the networks in which they operate provide a form of subsidy because state lawmakers can see that if they ingratiate themselves with network elites, this will be beneficial to their long-term political trajectory. In other words, sort of moving up the ladder of power by ingratiating yourselves with these elites. Second, if we sort of widen the lens a bit and look beyond material support and electoral incentives, political networks create a form of peer pressure. So there's a strand of organizational sociology that emphasizes how supporting particular policies that are favored by the sorts of people that one thinks about as one's peers within a particular network can over time just become constitutive of a lawmaker's professional identity. So there's a sense in which just being the sort of politician who favors the sorts of policies preferred by this network provides a kind of social motivation to enact new innovations that are favored by that network over time. And then lastly, in the form of answers to Professor Rose Ackerman, political networks can take advantage of the interdependence of the state and federal governments. That is, a group of organizations that obtain influence over the federal government can then use that influence and leverage it to catalyze experimentation in the states. So here we're now focusing on a theme that's fairly ubiquitous in Dean Gerken's work, the idea that neither the state or federal governments really presides over its own empire. They really govern shoulder to shoulder in a kind of tight regulatory space. And this interlock can unlock certain forms of experimentation. So for example, you just think about cooperative federalism programs like Medicaid often provide the impetus and resource push that you would need to get certain types of experiments off the ground that wouldn't otherwise exist without the federal government's intervention. Okay, so what does all this mean for legal doctrine? I'm just going to address this question at a fairly high level of abstraction because I don't have a ton of time. The laboratories myth has been invoked mostly to justify protections for state sovereignty, separating the federal governments and the state governments and the federal government. And that makes sense, I think, if the states really are 50 independent laboratories. You might think that the key to innovation is giving states room to operate free from the federal government, let every flower bloom, as it were, and you'll have a much lovelier set of flowers. But things look quite different if, for most intents and purposes, we have hundreds of laboratories operating within two political networks. And if, in fact, innovation is fueled not by separating state officials from the federal government, but by integrating them into networks that span across the states and vertically between the federal government and the state government. For one thing, federal state overlap isn't always going to be a minus. Sometimes it's going to be a plus. If national politics and national initiatives are fueling experimentation, then you don't necessarily want to hive off the state governments from the federal government's influence, at least not in every circumstance. At the same time, we don't want to be Pollyannish about the federal government's power. There are many ways the federal government can be used to shut down state level policy experiments. I mean, here there are thousands of examples, but just think about one. Think about the Trump administration's attempts to bully states and localities into shutting down their sanctuary policies. What I think all this means is that we should stop trying to keep the states and federal governments separate, and we should try to be regulating the cutthroat competition between the two political networks. So instead, what we propose is a version of process federalism, in which courts are going to play a kind of Elian role in regulating the interaction between the state governments and the federal government. Rather than making autonomy the goal, we should think about courts trying to ensure that federal state bargaining remains level and fair. So we should be policing federal state bargaining rather than federal and state boundaries. We need, as it were, kinds of rules of engagement between the state and federal governments. So in the paper, we engage in a thought experiment, recognizing that federalism promotes a lot of different values, and it's hard to weigh all those values at once in a single paper. But we just ask, if your goal was merely to promote policy innovation, then what sorts of doctrinal reforms would you favor, given the things that I've just argued in the beginning of this talk? And I'll just mention one now because I know I have only about a minute left. So we think that if this is in fact the way that policy innovation works, that preemption doctrine is going to have to change. The Supreme Court's doctrine tends to endorse a fairly sweeping version of preemption law, willing to find preemption anytime that state law even poses a conflict to the enactment or to the enforcement of federal law. But we think this is precisely the opposite of what the doctrine should be if we're right about how policy innovation works. What we should be striving to do is let state and federal regulation coexist, and to be more willing to allow tension between state and federal law. And we go into this in a lot more detail in the paper, but I think I'll just stop there because I know I've run out of time. Thanks very much.
Fabulous. Jake and Guha.
Right. Thank you very much to the conveners for having us, and to Richard for moderating us. So this piece that Guha and I wrote, and I'll talk for a few minutes and then pass over to Guha, but it's called Optional Legislation. And so we think this thing, optional legislation, is a new and interesting solution to legislative dysfunction in Washington. And the basic idea is that it's federal programming that states can opt into, but on the condition that they foot a higher tax bill to pay for that program. And then if a state opts out, the idea is that it's in no way subject to the bill. And as Chaz was saying, given that Democrats and Republicans each control their own sets of states effectively, we think that optional legislation will help to alleviate some of the legislative gridlock. Each party will effectively be able to govern at the federal level with some degree of independence from each other. So to give an example, consider Democratic proposals for an expanded public healthcare system, such as Medicare for all and the public option. And so we think, and I think you would agree that, these plans are all very politically fragile. So finding 60 votes in the current Senate for either of those plans is a non-starter. But you might say, well, what about 50 Democratic votes? So first, for that question to matter, we'd have to effectively eliminate the filibuster so that healthcare reform could pass with a simple majority vote. But there isn't Democratic support in the Senate for that. Only 19 senators have committed themselves to such a robust form of filibuster reform. And so, but anyways, it's moot anyways, because there aren't 50 Democratic senators who would vote for even the public option. And so optional legislation, we think, changes the story dramatically. So there are 27 states that are represented amongst the senators who caucus with the Democrats. And so while finding a majority or supermajority in Congress for healthcare reform is very unlikely, we think the chances improve dramatically at the state level. And so it's doubtful that all 27 of those states would opt into Medicare for all or the public option. But it's not hard to imagine that some number of these states, say 5 to 15 of them, would choose to join into some version of an expanded insurance program. And so a nationwide law would, of course, cover many more people. There are millions of individuals in those 5 to 15 states who are uninsured or underinsured, and they would stand to benefit greatly from an optional program. So our thought is, why wait to help them when the politics of a nationwide law, are so foreboding? So it's in this general way that we think optional legislation might be able to help us to sidestep some of this partisan drama. And so if Republicans don't like the policy, the idea is that they don't have to have it and they don't have to pay for it. But regardless, if an optional program is working in participating states, then additional states can, and we hope and I think they will opt in, later on. And so it's in these ways that we think optional programs resolve some of the issues that Chaz mentioned with the laboratories of democracy ideas. We think optional bills can hypercharge the laboratory's function that's afforded by the federal system. They enable states to experiment with programming that they would be unable or unwilling to experiment with on their own. And so in this way, we think well-managed optional programs might be an effective means of convincing people who are skeptical of progressive demands for more socialized system. So, and there is some evidence that this might work. So for instance, the Medicaid expansion associated with Obamacare, which the Supreme Court effectively converted into an option for the states, that's now been adopted by 38 states, many of which were initially totally opposed to the policy. So, one way that we like to think about optional legislation is that it embodies the two virtues of what our esteemed co-panelist in absentia, Heather Gerken, what she envisions as the federalism of the future. So first, it conceives of the states and the federal government in this cooperative or braided way. It eschews the New Deal understanding of states and the federal government as autonomous and competitive sovereigns. But secondly, it rejects the premise of the civil rights era, that decentralization necessarily favors conservative interests. So we think when expressed through optional bills, decentralization can favor the interests of both parties. But it's not just a matter of getting the bills passed. We think it has normative advantages as well. So more specifically, we think that optional bills are arguably more democratic than nationwide bills. And so this is true in the most basic sense, that like more people in red and blue states will be able to live under the legislative regime that they actually want. And then beyond this more individualistic conception of democracy, there's a more communal conception under which we think optional legislation arguably succeeds. So along these lines, maybe we can say that the community of progressives and the community of conservatives will be able to determine their own existences to a greater degree with optional bills, and that's a democratic virtue. So finally, just before handing it over to Guha, I'll just say that we don't think optional bills are always appropriate. So it does depend on the subject matter of the bill. So certain policy areas like immigration and foreign policy inherently cover the nation as a whole. So it wouldn't make sense to use an optional bill in that context. But more importantly, we think they're inappropriate in the context of basic or fundamental rights. You know, we don't think states should be able to opt out of the Constitution or the principle that each person has equal moral worth. So optional bills would never be appropriate for, you know, like civil rights and things in that category. With that, I'll hand it over to Guha. Thanks again.
Thanks, everyone. So excellent. So now we've talked about how this is a kind of novel solution to an enduring problem of partisanship. And I want to talk about how this is grounded upon and really building on structures that already exist. So, you know, in constitutional law, like in this area of state cooperation, interacting with federal power, we're not painting on a blank canvas at all. And we see three models that are instructive. So first, interstate compacts, conditional spending, and model legislation. And I'll talk about the first two just in the interest of time. So, you know, states have long entered into interstate compacts, especially on issues of local concern that impact those states. And, you know, in particular, like sort of environmental or geographical issues. Optional legislation is a type of compact with a few tweaks. It's federal legislation that's going to invite participation by states, and it would set up mechanisms for states to enter and exit those agreements. And by using the federal forum, there may be a richer negotiation on the terms of the compact itself. You know, who's going to bear what, right? You know, among these participant states. And that would be crucial to sort of protecting the interests of these various participant states. The other instructive model here is conditional spending. So, you know, it's typical for federal spending to be conditioned on state performance. And, you know, for the longest time, Congress had really near free reign to legislate with conditional spending and really obtain state performance. So the very big difference here, you know, it's the heart of our proposal, I think, is that there's no federal spending. It's going to be the participant states that are going to be paying for this. And so, you know, that is the key. Okay, so this is going to take us to the question about motivation. So why would states participate in this? Why would legislators vote for this? So let's take states first. So here we can think of a familiar dichotomy of like big states or small states, or, you know, similarly like net donor states or net beneficiary states. And let's talk about the net beneficiary, you know, the motivations of net beneficiary states are, you know, easy enough, right? Why would they want to enter this? Because they're going to benefit. But what about the net donor states? We see four motivations. First, there's altruism. Now, that might seem sort of idealistic or something, but, you know, it's often the same altruism that's leading states to adopt these programs internally. So, you know, why wouldn't we think that that would extend beyond state borders, right? You could imagine, you know, voters in those states thinking, yeah, sure, if we can expand this kind of, you know, legislation to other states, that'd be great. Second, you know, you might want, you know, these donor states might want to protect against downturns where, you know, if you have other states involved, they can hedge against that, you know, especially in kind of like the insurance, medical insurance context in that example. Third, relatedly, there may be an ambition for national adoption of a program. So the more states that you get involved, that may lead towards a greater adoption of the program. And finally, it might protect against certain kinds of pathological behaviors, flight to a particular state that has a program that could then collapse the program. So, having other states involved, even if you're a donor state, may hedge against that kind of movement. All right, well, what about legislators, right? And I'll focus on what we call the anti-legislator, those who are against the substance of the legislation, right? So why would they join forces in optional legislation? Well, they could, support optional legislation to stem the tide for a national adoption of such a program, right? Like they can just localize it. Another reason is they might genuinely support experimentation. And, relatedly, the experimentation may go well for them. It may show that the substance of the legislation is going to fail and it wouldn't impact their constituents, right? It's a great experiment for them, show that it's going to fail. They can make use of the optional legislation as well. So there may be programs that they can suggest that, their state constituents would rather adopt, and, they can use the same mechanism. They can also use optional legislation not to pay for things, right? They can say, well, why don't you guys just do that? Again, this harkens back to the point about stemming national adoption. All right, so finally, I want to just address this question. Is this just a thought experiment? How is this ever going to come to fruition? So we think the way partisan polarization is going, that this actually presents a genuine way forward. But it's also has perhaps a procedural role. And, at the moment, we see the filibuster stands as a burdensome obstacle for lots of legislation. And those who continue to stand by it tout its role in ensuring the Senate is, the world's most deliberative body, whatever that's supposed to mean, right? We think optional legislation can test that, right? Can test that claim about the role of the filibuster in particular. Optional legislation is an eminently reasonable compromise on so many issues. So if senators continue to gum up the works with the filibuster when optional legislation is an alternative on the table, then it makes clear that this is really about being obstreperous, right? And we think that might provide grounds for a genuine good faith filibuster exception. So with that, I'll give it back to Richard.
Wonderful. Thank you, everybody, for those great remarks on some very, very rich and useful papers. So I'll just take the pieces up in turn and offer a few reactions for your consideration. So starting with the piece on interpretation, I think my framing comment on this one is that it's not totally clear to me why it's framed as two types of two types of robotic interpretation versus one type of human interpretation, when all the interpretation you're talking about is being done by humans, and there's not really a discussion of what would make interpretation distinctively robotic. One might wonder what really is the capability limit that's preventing a machine from doing what you're calling human, especially when, again, there are humans doing the things that you say are robotic. And in particular, I'm excited about it, but I want to hear so much more about what human judgment or human interpretation is on your view. At times, it seems like it's not an inferential analysis like inductive or deductive reasoning, but rather is a kind of fiat or authorial choice. That's one possibility. Another possibility that the draft made me think about is that human judgment is drawing on background social values and norms in a way that the other kind of more text-driven inference is not. But if that's true, it made me wonder if the deductive-inductive distinction in robotic interpretation is really so apt, because if we're talking about social values, those also are susceptible to inductive or deductive reasoning, especially inductive reasoning. So that's kind of my first big question, is I just want to understand why human versus robots are being discussed here in that frame. So the second big comment has to do with this discussion of the Yates plurality, which I think is really interesting. And the idea that the tangible objects phrase at issue in that case is just a pleonasm or just kind of a throat clearing device, something that I don't think is actually intuitive to many human readers of that text, as you kind of suggested it might be. But having said that, I do think that your assessment of that seems quite plausible and compelling to me. It almost seems as though it's a more linguistically sophisticated version of the Noscitur canon used by the plurality. And so I wonder if part of what's happening here is you're drawing on linguistic insights, maybe pragmatic linguistic insights that could supplant or qualify some of the conventional canons like Noscitur or surplusage, or maybe provide a sounder basis for invoking those canons. But if so, it does seem to me that your reasoning is not so much oppositional to the Yeats plurality as it is deepening and enriching it. And that possibility made me think of something that maybe is the most exciting thought this draft gave me, which is that it seems like inductive reasoning is the natural ally on your account of human judgment. Or perhaps inductive reasoning is the path to what you call human judgment. And so the possibility that I think in the presentation you referred to rich contextual judgment, it just seems intuitive to me that if you're talking about rich context, you want to be inductive so that you can have a broad gaze and sweep in lots of insights. And again, if that's true, it seems to me that your relationship to the Yeats plurality is more one of enrichment of the Yeats plurality rather than opposition. And so the final kind of headline reaction I have has to do with this agony of judgment idea that drives your is part of what drives your argument that there's a hunger for robotic interpretation. So one question I had about this is whether the agony of judgment is really all that agonizing in light of the pleasure of power, which also comes from what a lot of these decision makers are doing when they engage in interpretation. So I think we need to look at the kind of the carrot side of the ledger here as well, to mix metaphors. So the second question I have about this is just phenomenologically or empirically. If the agony of judgment is what's driving this, I would think that judges would be the ones calling for robotic judgment, especially judges. And I'm not sure that we see that dynamic where judges are uniquely encouraging robotic analysis, but maybe I'm wrong about that. That would seem like a testable implication of your claim. And finally, it seems like, as I think you suggest briefly, the agony of judgment isn't really being eliminated under what you call robotic interpretation, but moved rather to a more legislative form. And so I wonder, is there a kind of economy of agony going on here where you eliminate agony in one place and it just shows up somewhere else and there's still the same amount of agony? And I'm not sure what would follow from that, but it's a possibility that I'd be curious to hear more about. Okay, so anyway, very interesting stuff. So the laboratories paper. So here my framing reaction has to do with the way you treat the Brandeis Laboratories of Democracy image or metaphor in the first place. So you come out pretty hot in the paper saying that it's a myth or a campfire story, but at the end of the day, you seem to agree with a lot of its essence, or the idea that states are uniquely situated to foster innovation in one way or another. And so if there's a correction as to the Brandeis account, as opposed to a deepening of it, it seems like the correction has to do with the source of the innovation, where you say that under the normal view, Brandeis says the innovation comes from within the state, whereas you say it's from out the state. But I'm not sure that Brandeis is, as far as he wrote about it, or maybe even some of the commentators are taking a position one way or the other on where the innovation comes from. At the end of the day, even on your account, as you said in your presentation, the states have to be the ones who do the things for the innovation to be realized. So it seems, again, like you're pushing the analysis deeper and earlier, which is great, but not in opposition to what Brandeis says. You're kind of taking a position on something that he maybe didn't take a position on, and maybe people writing in his wake are not taking a position on. Now, having said all that, there is one way that I think the original Brandeis thing actually seems more correct than your framing, because you want to say that the interstate groups are the real laboratories. I don't think you said that in your presentation, interestingly, but the paper says that. And that seems odd to me, because again, on your view, the states are the place where the experiment happens, and we see it, and we see the actual results. So your view seems to me more to be about who's doing the experiment, not what the laboratory is. For you, the laboratory is still the state, but the theorists who generate the idea for the experiment are the interstate, non-state actors, and their theory is kind of, maybe they're coming into the state lab and doing the experiment themselves. Maybe they're giving ideas to the state experimenters. But anyway, this is the kind of metaphorical elaboration that I think would help me, and maybe make it seem as though you're not cutting down Brandeis again so much, but enriching his original metaphor. Okay, so that's my broadest comment. Second comment has to do with the costs of the situation that you, I think, very compellingly described to be the reality. In other words, you're saying these interstate groups are a big part of what's driving innovation at the state level. I think it's very persuasive analysis, consistent with some prior work that you discussed by your co-author, in fact. And so I think the main reaction I had about this is this really something we should be celebrating and acquiescing to, or is it possible that these interstate groups, these regional groups, these partisan groups, et cetera, are they trying to take advantage of the inability of states to come up with their own experiment ideas to kind of co-opt the state system and foist one-size-fit-all solutions on the government and on states and on the nation in general? Another way to look at it might be that in fact, maybe the laboratories are dominated by these interstate theorists, as I've suggested they are, but that's kind of lamentable, or at least a mixed good. And so maybe we need to have some reforms that actually move things toward the idiosyncratic, truly local federalism that Brandeis is more often associated with. Okay, so that's the second big comment. It's kind of, should we be happy about the story you're telling, and should we actually be fighting the story if we can? And so that leads to my third comment, which has to do with the prescriptions. And I thought this was all very, very enlightening. I think a lot of the proposals you make are consistent with what people who are on the pro-federalism side say in general, like you're skeptical of the presumption, you're skeptical of a lot of preemption, you want the presumption against preemption to kind of come back. That all makes sense. One of the more, I think, idiosyncratic proposals you make, it has to do with Prince, because you don't want to say that Prince and anti-commandeering is just wholly right or wholly wrong. You have this kind of nuanced picture of it that has to do with fostering the kind of negotiation that you mentioned in your presentation. And so you support a highly contextual inquiry that asks about whether there are, your phrase, opportunities for uncooperative federalism. And I'll just kind of pick this out as an example, because I think it's your most interesting proposal, most unique proposal, but also maybe one that shows the limitations of this approach, for me at least, because it's hard for me to imagine a court even undertaking that inquiry, much less undertaking that inquiry in a workable way, a way that wouldn't be prone to bias and unpredictability. And so if that's the right analysis, if you've taken the reader that far, I think a very natural reaction is to say, well, then Prince actually got it right, maybe, because it adopted a more bright line rule that's more administrable, errs on the side of state innovation, and still allows for a lot of uncooperative federalism, as you and other people have documented. So I wonder if there may be some more room for some practical judgment about doctrine to come in and maybe resist the bottom line you offer, and more consistent actually with what the court has done, and maybe some other scholarship. Okay, last but not least, by any stretch of the imagination, we have the optional legislation piece. So yet again, I have a framing reaction, and the framing reaction is that this paper presents itself as being about what I would think of as one kind of multi-state subnational coordination. And that kind is, well, I might relabel it optional federal legislation. And I wonder if it could be useful to reframe the discussion, or at least consider reframing the discussion more broadly about all multi-state subnational coordination, in which the specific proposal you're making is one good version. And things like interstate compacts would then come in, rather than being something you're kind of casting as a rival to shoot down. And so if you were to reframe it that way, I think the interstate compact discussion, which you do talk about, would deserve a ton more attention. So one question I have about it is, why in fact do we not see interstate compacts doing a lot of the things that you're talking about doing, since it does seem, as you say, to be quite a similar mode of reasoning? If the interstate compacts are not working or not attractive, maybe that the lessons there carry over to what you're talking about. And so to my mind, the starkest distinction between the two things, the optional federal legislation you want and interstate compacts, excuse me, seems to have to do with who does the initiating. Is it initiated by state actors or federal actors? Now, if that's right, that gives you something to work with, but I'm not sure that it's entirely reassuring, because the possibility that federal actors don't like to react to states could also imply that they don't like to hand over the reins of power to states. And in that regard, I think it's actually somewhat disconcerting for you that the Medicaid expansion became optional, not because of anything Congress did, but because of something the Supreme Court did. And this is an example of how by broadening the umbrella or whatever, bringing more things under the tent, you might be able to strengthen your argument, but also address some potential concerns. Second broad point about this piece had to do with scope. And these are some things that were repeated during the presentation as well. The idea that immigration is inherently a national topic, but that seems to require a lot more explanation, because we've seen a lot of local experimentation, I think, on immigration issues. Sanctuary cities is just one example. And also this idea that rights variation at the local level would be odious. I mean, in some sense that may be right, but the very things that you're talking about seem like they could be characterized as rights: healthcare, universal basic income. So I would just need to see a lot more explanation of how we know what kind of topic is in the analysis and what type is out. And you seem to be eager to push things out that, again, I would bring in if I were in your position. Now, one thing that I had actually thought of as an escape that I think you mentioned during the presentation is that, well, the stuff that's out is whatever courts do when they're enforcing the Constitution, because that's codified, it's federal, that can't be within our ambit. And I think that that's right that gets you out of some of these questions at least, but it also raises them again because right now, in particular with abortion rights being hotly debated, whether courts should allow more local variation with respect to what have long been recognized to be constitutional rights is also an open question. So I don't think that path out is a complete solution either. Okay, and finally, I have some questions about the practicalities of this. You frame it, I think fairly, as what's in it for prosperous states under your regime. And I think part of what that question tees up for me is that there are a lot of benefits to having the normal federal legislation, not just benefits in terms of how do we get to the outcomes we want, but benefits in terms of why people would do it. So you might think that the normal federal legislation is about large numbers of states redistributing goods from prosperous states, especially when the prosperous states are ideologically aligned with that outcome. But because you're not doing the redistribution based on the number of states or the population within the states, you have, as you acknowledge, you have to go uphill to overcome the prosperous states' disinclination to share the wealth literally. And so I want to hear a lot more about the practicalities of that. One interesting idea you have is that the states that have anti-deficit laws against deficit spending could draw on the federal deficit power. I like that idea. I want to see so much more about that. Would that violate the state's anti-deficit laws? Would that actually involve drawing on national funds in some way? But that seemed promising, but again, I have questions about that. And I also wonder whether the federal legislation works, just in fact, as a mode of coordination and policy achievement across a national scale, partly because it has a pretty powerful lock-in mechanism. And I wonder how you know that there wouldn't be a lot of opportunistic exit under your regime when the going gets tough, especially again, if you have this state budgetary restriction happening. And so in a way, I think part of the excitement, again, about broadening your analysis to be about the idea of regional interstate cooperation in general, is that it would help shed light on the normal way that we have that kind of cooperation. Okay, so I myself have now maxed out my time. I'm going to allow the panelists to raise your hands or chat me or just pipe up and comment on anything I've said or what one another has said, and then please chat in a question mark or something like that, and I'll keep the queue. Thank you so much. Jake, go for it.
Sure. Thank you for these very helpful comments. I think, Guhan, I probably agree with everything you said, to be honest. So as to the viewing optional legislation as one example of like a broader set of, I don't know how you describe it as, multi-state organizations or agreements. So basically, I would say that, we basically view optional legislation as an interstate compact accelerator. For various reasons, and maybe we could debate about what those reasons are. Interstate compacts are extremely rare. Like each state is party to, I think on average, a few dozen of them, whereas obviously there's like thousands of federal bills. And so we think that they're so limited largely for reasons of a political culture, where we just look to Congress, like we have Congress to solve, interstate issues. So why would we go to an interstate compact, which for historically is only used for like cross-border issues and like environmental issues or bridges that cross multiple states and things like that. But we basically view this in the same way as an interstate compact. We just think that Congress can be useful effectively as a means of making more of them, and kind of like opening us up intellectually to the idea that like, okay, we can actually use Congress to do things like this. But generally, I think we'd be very open to thinking about like more broadly, about multi-state agreements that might be a solution to legislative dysfunction. The scope point, I don't know that we feel super strongly about this. I think that we are aware that it's a point of debate in terms of what might qualify, as a fundamental right that would be inappropriate to use optional legislation for. I mean, we generally take the view that, if there can be reasonable disagreement about whether, the fair terms of social cooperation will lead to a certain policy, then that's an appropriate candidate for optional bills. So, you know, the size of a social welfare state, you know, I think we would say that people could view the fair terms of social cooperation in ways that lead to a really small social welfare state or to a really robust social welfare state. And so we think that's appropriate for optional legislation. You know, we use the example of civil rights as something being that would be inappropriate to say that we could have like a checkerboard statute for civil rights. But if someone, you know, disagreed with that, I think we'd be open to hearing exactly how they thought it was compatible with like human equality. So we don't want to be rigid in terms of what's in and what's out. But we're just aware that that's probably a point of debate and contention moving forward. I don't know, Guha, do you want to say more about
yeah, I think all
or opportunistic exits or?
Yeah, no, I think that's completely right. And I think, and with respect to the practicalities, all I say is like, there's just a ton of interesting issues there, especially on how the tax base would operate, you know, for participant states. And we think that there would be, you know, hopefully rich negotiation on that kind of thing. But that could be really interesting and it's a place for us to explore further. And so, yeah, and I might just throw one question to Chaz about his paper, great paper. One thing I was wondering about is on participation, preemption. Like, you know, if you loosen up preemption, is there a worry that like sort of obstreperous states may sort of challenge the sort of the democratic, you know, like the democratic election of the federal government may just like sort of stop the federal government in its heels, like we see states like Texas doing on so many issues. And so I wonder if there is a kind of like, well, if you open up, you know, if you loosen up preemption, do you sort of challenge another kind of democratic character of the nation?
Yeah, so just on the question that was just posed to us, I mean, I think it's certainly the case that there has to be some preemption doctrine, right? I mean, that's the supremacy clause, and so you have to have some version of it. You can't just let the states defy federal law. But I think we also want to, I mean, in general, our point about preemption is that it should just be a lot more context sensitive, because there are some domains in which you want to allow state officials who disagree or who have a different vision of the same federal policy to deviate from what the federal government wants them to do. And often it's that form of deviation. It's sort of them deviating from a program that they don't want to do in the first place that generates an interesting kind of experimentation that wouldn't otherwise exist, because if they had their way, they would do something totally different. And if we have a robust federal preemption doctrine, they just have to do it the way that the federal government wants them to do. So it's that kind of thing that we're trying to build in, but you're certainly right, there has to be a stopping point. I was just going to say like a few things about what Richard said. Richard, I totally agree with the framing point. This might just be an area where we haven't killed all of our darlings yet when it comes to the rhetoric in the paper. And the draft has gone back and forth about, is it 1,000 laboratories? Is it 50 laboratories? Is it 2 laboratories? You know, you can even see Heather refer to it as 2 laboratories if you go back and look at some of her papers that cite this working draft. And so that's something I totally agree with you on. And just on the point about capture, I also agree with this point that some of, you know, maximizing policy innovation in the current landscape has some lamentable consequences, right? Because you're maximizing the innovations that are put forward by captured interests, but not all, you know, interests that take advantage of state governments in this way are captured interests. Some of them are things I think that we could all agree are pro-social innovations. And so I don't know, I guess we should think more about whether any of our proposals could be used to better optimize that balance. But I think it's the issue of whether or not how to handle capture is something that we just think is beyond the scope of, you know, how to maximize innovation. And maybe it's something that you deal with by tweaking other areas of the law. But anyway, great comments. Thanks very much.
Okay, we have a queue developing. It is Kyle and Jill. I just want to make sure, do you want to make a brief remark, or you just want to go right to the questions?
I can make a remark in response to the thing about why do we frame this as a robotic interpretation when it's fact that when it's people who are doing it? And thanks for laying it out that way, because it really bears walking through on our part. But my hunch is that people, when they have to make their knowledge of language explicit, when they're doing explicit reasoning about language, we get it's like our inner cave dweller comes out, and we need to tether ourselves to the world of concreteness and things. I always have a potato on hand, because when I need to think, so I think it's a really good example of the thing. We want everything to be a potato and act like a potato. And the most potato-like things that we have in language are words, individual words. They've got space around them. We expect to be able to move them from one place to another, and they won't turn into butterflies or, disband somehow. And I think that it's the need to justify without the tools and my students don't even believe in pragmatics, right? That we draw inferences from based on some basic principles, the big one being relevance, right? And if you're going to talk about relevance, relevance is about what matters, and what matters is what people have a reason to care about. And so so I think there's it gets us into this very uncomfortable value-laden zone, which is inescapable if you're actually doing communication in English, that, we want to retreat into this, sort of childlike world of, putting an object in our mouth to understand it better. And so I think it's, I think the fact that I think natural language competencies are much, much better, like fast on the fly in the millisecond. Linguistic judgments and pragmatic judgments are much more on the money than when we sit down and get paid, in the hundreds of thousands of dollars to analyze a text, because all we have are semantics, these word level semantics and dictionaries. So I guess that's a drum that I'm beating all the time.
Yeah, it's all fabulous, all those comments. Okay, great. So we have a queue here. Christine, I think, is first. Is that right?
Yes.
Yes, please.
Hi, thank you. And I enjoyed all the presentations. I had a specific question for Kyle and Jill. I was curious if robotic interpretation is inherently biased or might be inherently biased towards static interpretation. And I guess the example I'm thinking of is the statute passed some 40 years ago that allows OSHA to regulate new hazards causing grave dangers to employees in the workplace. And if you go back 40 years ago, there's no new hazard that involves COVID-19. But I think what Congress meant was maybe to opt out of that existing understanding of new hazards and say, I don't know what the new hazard will be. I intend to hand this off to an agency who might be capable of figuring that out based on facts that Congress currently don't have before me. So I just wondered what you think about that, if that idea of trying to have some kind of robotic interpretation where by definition, as I understand it, you're looking back in time to some historical data set of meaning, will make it always a static interpretation or understanding of particular texts.
Oh, hang on. Thank you for that. That's, that's music to my ears. I think that one of the things about pragmatic judgment is that it works off of I know that you know that I know that you know, some basics about our common ground, and it sort of builds in like a flexibility over time, so that I can leave my kids with a set of instructions and expect that they will try to work out what's probably what I'm probably meant, what I might do in a given situation that comes up. So I think that's, I think that's true. And I think it's probably a little bit of a hint as to why some of the politics of these robotic approaches break down or ideologically the way that they do.
Great. So we have 2 more people in the queue, and I understand that we can go 10 minutes over as long as the queue is going. So we may have, I guess, up to 15 more minutes. Shalev, I think, is next, and then David.
Hey, thanks. I really enjoyed all the papers. I had a question for Kyle and Jill. and it's I think related to Richard's question, but it's kind of about the scope of the project. Is it just about legal interpretation of texts and statutes? Or another way to put it is, or another kind of related question or confusion I had was what the relationship was between the inductive deductive kind of dichotomy you draw and the search for robots. So when I think of the inductive deductive dichotomy, so Jill carries around a potato, I carry around this book, From Apology to Utopia by Marty Koskiniemi, in my pocket. Everyone, no, I'm just kidding. I'm in my office. I had it. But this is a book about the deductive inductive dichotomy, and his argument is basically that international legal argumentation goes from a spectrum of apology, which is purely inductive. You just ask what state action what is state action, and then you say that's what the law is, but that's an apology. It's not really law. You're just describing human behavior. On the other hand, you have utopia, where people take these broad principles like self-determination or territorial integrity and try to make legal claims about that, but it turns out it's utopian because it doesn't actually match state behavior. And so he argues that basically international legal argumentation goes from polar positions of apology to utopia and back and forth, and that's kind of the nature of the field. I bring that up because it has nothing to do with robots or the kind of agony of judgment or any of that. And so the question is kind of, if we can have this inductive, deductive debates everywhere, what is special about it in this area of statutory interpretation that leads you to this sort of inference that it is really it's really evidence of a search for robots?
Yeah, thanks. That's a really helpful. I don't carry that one around in my pocket, so I might have to get a copy of the book. Thank you. So kind of two related thoughts in response to that. So one is that my view, at least, is that a fair amount of this as a claim about the nature of human judgment generalizes, and that it's not really distinctive to texts, or even more specifically to legal texts, but that it's really about what we take the nature of judgment as a distinctive kind of cognitive faculty, like a sort of mixed sensory and kind of normative or kind of moral faculty to be. And so for me, the kind of intellectual origin of some of this thinking, we could talk about in epistemology terms as the kind of the excluded middle of the deductive inductive dichotomy, which is a notion of abductive reasoning. So some sense of kind of developing an account or a hypothesis about what it is that matters, that is richly contextual and does take its cues from the world. So to Richard's point, is kind of inductive. It's definitely not deductive. It is a close cousin of induction, or depending on one's view of these fine distinctions, a subset of induction, but that it is kind of different from just let's look at as many instances as possible induction. It's a kind of induction that is about what we would think of in the law as exemplars of paradigm cases is probably the closest analogy in jurisprudence to this form of thinking. And then the other intellectual origin to this is, for me personally, is Hannah Arendt's writing about thinking, what thinking is, because I think that account of thought, which she traces to Kant, she thinks it's just Kant's account of thought, is a kind of grappling with, precisely with the interaction of broad conceptual kind of abstract, or on Shaleb's, formulation, utopian kinds of principles that we can derive from somewhere completely other than what we see in our everyday world, and the everyday world that we actually see and interact with. And that's where this sort of the real thinking gets done, in the kind of combination or collision between those two things. So the famous account of like why Eichmann went so wrong is that he's failing to do this, right? He's failing to take the abstract program and think about what its implementation involves, and then kind of reason back and forth. It's not like clear that it's just bad principles or clear that it's bad practices. It's the sort of failure to engage with the combination. And that seems to me to be roughly the kind of account of judgment that we think is at play in the legal contexts here. So I would expect it to generalize, but also be sort of definitely at play in other legal fields as well. And I really do want to reference the book that you held up. Thanks.
Great. So we're going to keep going because there's still a queue and we have some bonus time here. David.
Thanks. This question is also for Jill and Kyle, and I hope the question is not too pedestrian, but I'm curious to what extent the idea of robotic judging maps onto kind of a very strict or rigid textualism versus statutory interpretation that looks at purpose and intent. Whether you have some examples of non-robotic judging that you would kind of hold up, and if you have any thoughts about the Bostock case, for example, is that we're both the majority and the dissent engaged in a kind of robotic judging approach in that case.
Oh, thanks, David. Yeah, we're very intrigued by the Bostock case, and I think both of us would say that that case, all of the opinions fail to engage the concept of discrimination based on sex, and that's one of the things that we think is we thought that's sort of our Rock'em Sock'em Robots case, let's see. Kyle, is there anything more that you would want to add onto that?
Just that we've been puzzling ourselves. I don't think your question is pedestrian at all. I mean, we've been puzzling ourselves over how this what we're talking about is kind of already indexed to an internal debate, especially within statutory interpretation, but it may be you can find the same kind of variants of it in various kinds of constitutionalism, living constitutionalism, common law constitutionalism, whatever, about just like the role of purpose. And I think that where we currently are on it, and this is very much a work in progress component of the work in progress. So we love thoughts, is that there are some strands of purposivism, or there's some deployments of it at any rate, that actually look a lot like what we're calling deductive robotic interpretation. It's just that the program, so to speak, that they're imagining the judge to be sort of running is a more sophisticated or at any rate a more complicated one, right? So the model is still, the judicial layer is a kind of implementation, input output functionality layer in the same way that a computer would be, but that what the function actually is one that attends to different kinds of inputs and maybe puts them together in a different sort of way. It looks at things like legislative history and all the usual stuff to try to figure out like what were the goals that the words were trying to instantiate or to kind of call our attention to. And then there's going to be some variants of purposivism that may genuinely be just good examples of what we're calling kind of, the real deal, like the human judgment stuff. And that kind of attention to purpose is the language that this particular set of discussions has centered on, and that we would talk about in terms of things like relevancy and pragmatic judgments, but that they really have the same kind of thing in mind. And perhaps, legal pragmatism, if that is a subset of purposivism, I'm not sure. They might just be kind of close siblings or whatnot. But it could be that not that we would agree with every opinion that he wrote, but the Posnerian, the kind of Holmesian Posnerian sort of sensibility is essentially what we are talking about. It's just that we're giving it a slightly different gloss. I'm undecided on that point, but I think purposivism itself kind of subdivides, I guess, is the main hypothesis.
Terrific. So we have about 5-ish minutes left. I think Guha and Jake, both want to ask a question. Maybe you could go one after the other, and then we could take it. You both go before any of the answers. Maybe would that be okay? Great.
Yeah. So I just wanted to ask really about kind of the deductive, inductive, and abductive sort of groupings of reasoning. In particular, I'm thinking about like what I think of as like a normal formal kind of thing, look at dictionaries and then kind of apply the dictionaries to get something. But dictionaries themselves are just the product of induction and abduction, right? Like that's what, how dictionaries come about. And so I'm wondering like if the categories of deductive thinking really have large parts of induction and abduction just kind of like siloed, or that they're called upon as using a program metaphor, kind of like what your reflection is on that division.
I had two questions. One was for Chaz, which is basically just to reemphasize what Richard was saying, where I really feel like there's a lot at stake in terms of whether it's 100 laboratories or 2, because in the paper, it did seem like it was 2 laboratories. And my worry was that that created like experimentation without learning, where they're just in these totally separate silos. Whereas if it is really 100 laboratories, it seems like, intra-party that they can, learn. Whereas, Alabama's not going to learn anything from California and vice versa. So that I just feel like there's a lot at stake in that empirical question. And then my question for Kyle and Jill was like one further challenge for robot judges. Maybe they can come to the right decision, but can they explain their reasoning to the people who are impacted? Which seems like a central role that we want judges to have. That seems challenging for robots. And then related to that is whether robot judges can fulfill a classic, like contested criminal law function of judges as censuring people who have committed crimes. Like the idea of censuring really seems like a member, I as representative of the community, or we as representatives of the community are censuring you for violating the law. And so it seems hard for a robot judge to fulfill that function. Maybe that's a thought. Thank you.
Okay, I think what we're going to do is, Chaz, could you answer the question? And then I want to make sure we give time for Bijal to ask a question too.
Yeah, but before recently, there would have been no question that it's not just 2 laboratories, that there are many, because the Republican Party in the Northeast wasn't the same as the Republican Party in the Southwest and what have you. With the sort of increasing, way in which the parties have become all-consuming and very similar across the country, there's a greater temptation when we were writing this to say that there was 2. But the reason we moved away from that in later drafts is just because there are some issues where the parties have very clearly staked out positions and everybody who's a member of the party goes along with those positions. But there's lots of other issues where the interest groups that are relevant, have a myriad of different views. And so it's really, there's lots of different variation. And so I think at the end of the day, we went with hundreds over 2, but you can see it from many different angles. But I still think that the insights flow from the idea that there are hundreds, not 2.
Terrific. Our final question, Bijal.
Hi, thank you for a great set of presentations. So this question is for Jake and Guha, and I'll be honest, I'm asking you more for psychological support than anything else, because my first response to this paper was terror, which is this. I understand that it's really just a response, a sort of concession to the fact of political polarization, but this describes a world in which states are that much less beholden to our federal system of government. And so I wondered if you might speak to, beyond sort of helping me manage my terror at that idea, if you might speak to the sort of potential future ramifications of moving in this direction, where we're now dismantling this essential sort of way in which, federalist principles are kept in check. I'm not sure if the question makes sense, but it's a sort of a general concern with the proposal as a whole. Thank you.
I could take a stab at it. One argument is to say that it's probably Pareto optimal certainly from a progressive perspective, probably in the sense that, individuals in red states who we might be worried about aren't going to be any worse off than they are now, because no bills are really getting passed, whereas individuals in blue states might be better off. And so, I think that's like the biggest point to make in terms of the terror. The other, I don't know, Gua, do you want to take a stab at this? So we usually get 2 responses. One is that this is useless, or this is going to like be so useful that it will destroy the republic. So yeah, I think our thoughts are one, that it's Pareto optimal. 2 is that it is democratic. So and I think we're okay with that. So if individuals in separate collections of states have different conceptions of social justice, within certain bounds, we're okay with them, running these experiments for a few years.
Yeah, the only thing I would add is I think like this may be a way of sort of, I mean, we started this with a way of like lowering the temperature. And in fact, if we think polarization is going to lead to like these sort of like that, detrimental consequences, this might actually just, make that more gradual or even stop it. So that's kind of our thinking. But I am also worried about increasing polarization in the way that you talk about. So I'm terrified.
On that outside the box conclusion to our panel, I'd like to thank everybody for joining, participating. It's been a real pleasure, and I look forward to seeing all of you in person, I hope before too long. Thanks, everybody.